Ms Hodkins.
My lady, my lords, we were before the short adjournment on the question of whether the knowledge of Mr Bayraktaris is to be attributed to Delos for the purposes of Section 4 of the Insurance Act.
Yes.
I turn therefore to say something about Delos, and I hope that nothing I say is going to be other than common ground. Delos is a special purpose vehicle incorporated under Marshall Islands law. It was incorporated according to Mr Bayraktaris in his witness statement, and his witness statements are in the supplementary bundles, for the purposes of ordering a new build vessel, not the Win-Win, a different vessel. It's beneficially owned by members of the Mundreas family, and they are the interests behind the NGM group. The vessel Win-Win was acquired by Delos in around 2017, and from that time onwards, Delos did nothing apart from owning her until she was sold. And that happened after her release in July 2021. In other words, Delos is a typical single ship company of a kind whose use by a group such as NGM will be very familiar indeed to this court. The corporate documents of Delos are in the supplementary bundle at tab 3, pages 6 and following. It's probably just worth turning those up. So you have certificates of incorporation. Then at page 9 of the Articles of Incorporation, one sees that the purpose of the corporation is set out in wide terms on page 10, but it includes the purchase, acquisition, mortgage, charter, etc. of ships. If we go to page 17, we can see that these articles are signed off by Mr Bayraktaris as a proxy for the incorporator being presumably a member of the Mundreas family. They record that Mr Bayraktaris is a director. Why Mr Bayraktaris? Well, his evidence in his witness statements is that it was a service he performed for the NGM group, as he did for other clients, because he was the group's trusted external lawyer. The bylaws appear on the following pages, and I don't want to crawl through these in detail, but if we go to page 19, we can see under directors that the affairs, business and property of the corporation are to be managed by a board to consist of at least one director. That's, of course, Mr Bayraktaris. If we go to page 21, under officers, we see that the board has to appoint either a president, secretary and treasurer, or a managing director and secretary, and such officers as it may deem necessary. And the president, secretary and treasurer so appointed is Mr Bayraktaris. There were no other officers. And if we turn the page to page 22, we can see that in his capacity as President, Secretary and Treasurer, Mr Bayraktaris had very wide powers, including custody over Delos's effects, the supervision of Delos's accounts, and the power to affix the common seal. In other words, the power to hold himself out to the world as Delos. And indeed, the judge accepted that on paper, Mr Bayraktaris did have very wide-ranging powers indeed, as she put it.
You said a moment ago that after the acquisition,
yes,
Delos did nothing, but presumably, I don't think we're told, but presumably it was the contracting party under charter parties and bills of lading.
I accept that, yes. Yeah. Now, it's right, my lady, my lords, and we accept that Mr Bayraktaris agreed by contract to exercise his powers in accordance with instructions given to him by the Mundreas family. And one sees that in the next tab, at tab 4. That's an indemnity agreement for the provision of his services as director, of even date with the corporate documents at which we have just been looking. And it does make clear that Mr. Bayraktaris is agreeing to exercise his powers as a director only in accordance with the instructions received from the principals or the company. That is all true. Does this agreement make him in some way not a proper director, or mean that he doesn't have the powers he has on paper, or doesn't owe the duties of a director? And the answer we say is no, it doesn't. It is not the law, there's no suggestion that Marshall Islands law differs from English law in this regard, that a nominee director is somehow not a proper director who owes director's duties merely because he has agreed to fetter his discretion. So, and I accept this as theoretical, if Mr. Bayraktaris were to find himself in a position where the interests of the company conflicted with his contractual obligations under this letter, then his primary obligation would be, as a director, to act in the interests of the company and not to conform with his instructions. And you will be familiar, I'm sure, with the line of English authorities that deals with that, and I'm thinking of the Bolting case, which is in your authorities bundles, though I don't propose to take you to it. At tab 11, the position is now somewhat altered under English law by section 173 of the Companies Act. But does it make him not a proper director? No, we say it doesn't. This private agreement, which is between him and Mr. Mundreas, not made available to all the world, may not even be enforceable as against all the world, though it may be enforceable as between him and the Mundreases. Against that background, I turn, my lady, my lords, to the specific
Sorry,
respect.
but that wouldn't be a matter of English law whether it was enforceable other than between the parties, would it?
No, it wouldn't. It would be a matter of Marshall Islands law. I accept that.
So we don't know is the answer to that.
We don't know. I think the furthest that I can go is this. There's no suggestion, as I've said, that Mr. Bayraktaris isn't a real director. Nominee director is not some separate category of person, in the same way that a non-executive director is not a separate category of person. There is no suggestion that Marshall Islands law differs from English law. What I can't help you with, to the extent they're relevant or interesting, is the niceties of the Marshall Island Business Corporations Act. I don't think it has an equivalent of section 173 for what it's worth, but I suspect it might not matter. I think the way in which I put the point is that contracting to act in accordance with instructions doesn't mean that your powers don't exist, and doesn't mean that you are not a director.
Yep,
in the
that was
sense
your
in which
submission.
the law understands that. That is my submission. Against that background, my lady, my lords, I turn to the specific respects in which we say the judge went wrong in concluding that Mr. Bayraktaris was not senior management of Delos. First, we say that she approached the question of the insured's activities wrongly for the purposes of section 4.8c of the Act. It probably is worth taking out the Act again if you don't have it to hand. That is in Authorities Bundle 4, which I've temporarily lost. Tab 45. Now, we say, it's our submission, that the judge approached the question of what is meant by the insured's activities wrongly for the purposes of section 4.8c, particularly in circumstances where the policy on the vessel was a composite one, insuring the different assureds in relation to their own interests. Now, I'll come back in due course to the other arguments made as to the composite nature of the policy, but in this context I'm focusing on it in relation to the knowledge requirement. We know that the three assureds are Delos, NGM and FML, not the bank, which is an assignee. what do those three entities do? Delos owns the vessel. It's a one-ship company.
Sorry, was the bank not a mortgagee?
It's a mortgagee, and it's an assignee and a loss payee, my lord. It's not a separate co-assured. So I don't think this is disputed. It can't be in any better position than any of the other three claimants. In other words...
It's not insured as a mortgagee?
No, it's not. It's not a co-assured. It's an assignee of the rights of the first, second and third claimants, and a loss payee.
Thank you.
And it's not suggested, therefore, by my learned friends that it's in some better position than any of the other assureds. So I'm focusing, therefore, on the first, second and third claimants. Does Delos carry out the commercial management of the vessel? That's to say, decide whether she's chartered, to whom she's chartered, which cargoes she carries, where she goes, what she's going to charge by way of freight and hire? No, clearly not. That is done on Delos' behalf by NGM, the commercial managers. Second claimant. Under this composite policy, NGM has its own separate contract of insurance. Does Delos carry out the technical management of the vessel? Does it arrange her crew? Does it decide when and where she's going to be repaired? Again, clearly not. That's done by FML, the third claimant, her technical managers. Again, under this composite policy of insurance, FML have their own separate contract of insurance. The judge found that Delos' activities included operating the vessel for profit. It suggested that that's a factual finding which you can't disturb. I don't accept that. The facts are known. There's no dispute as to what the different parties within the organisation did. The dispute is as to the application of section 4.8 given the undisputed facts. My submission is that operating the vessel for profit is what the commercial management and the technical management were doing. That was their job. And where there are several co-assureds, each an assured under the same composite policy as regards their interests relating to the one asset, the ship, and thus each with a separate contract of insurance, the determination of what constitutes activities for the purposes of section 4.8c must, in my submission, take into account the different interests of those co-assureds.
Would charter hire be paid into a bank account in the name of Delos?
We don't know.
And would profits earned, if they were happy enough to earn profits, be profits of Delos? Probably for tax reasons, quite important that they should be, I would have thought.
I don't imagine they stay there, my lord. They might go in there. Again, we don't know.
Well, I don't suppose they do stay there, but it's probably quite important that the profits are recorded as being in the Marshall Islands entity, rather than, for example, in a legal entity. I mean, you're the insurers, you may not know all that.
I'm sorry, my lord.
I said you're the insurers, you may not know all that.
Exactly. We don't know the details. What we do know is what Mr. Bayraktaris said he did, and I'm going to come to that presently. But your lordship has focused on matters that are financial, and what we submit is that the activities of a one-ship company that has contracted with others to carry out the commercial and technical management of the vessel are essentially financial and legal.
Sorry, the activity of Delos is financial and
essentially
legal.
financial and legal, and they are incidents of the fact that Delos owns the vessel. And if that is right, the question is then, did Mr. Bayraktaris, as the sole director, play a significant role in the making of decisions as to how those activities were to be managed or organised? Well, we don't pin our colours to the management mast.
So, sorry.
Yes.
When Delos entered into a charter party in its own name,
Yes.
Does that fall within your financial and legal?
It entered, on this hypothesis, it would have entered the charter in its own name, my lord. But as to the persons who did it, others were doing it for Delos. So Delos, there's a legal activity in the sense that it becomes a party to their charter. So that falls within my legal and financial rubric. As to which entity actually does that, it's NGM. They're the commercial managers. They are the people who are on the phone to the brokers and making the decisions about the conclusion of that charter.
But aren't we concerned under 8C, when we're focusing on the insured's activities, just at what those activities are, rather than who is doing them on behalf of the insured? There are other parts of the wording which are concerned with that.
My lord, we are, but in the context of a composite policy, where there are different insureds with different interests in relation to the same vessel, my submission is that you have to look at each of those separately, because each has their own contract. If it's NGM who are carrying out the activity for these purposes of deciding what the vessel does and what hire she charges and so on, then those can't also be the activities of Delos, because then there's overlap.
Well, I'm not sure about that. They're assured for their own interest.
Yep.
Delos's interest is in owning the vessel as a profit-earning chattel. NGM's interest, for what it's worth, is probably quite minor under the terms of the policy and what it can claim for in its own name.
But the judge's finding, my lord, was that Delos's activities included operating the vessel for profit.
Yes.
And my submission is that Delos wasn't operating the vessel for profit. That was NGM that was doing that.
But I'm not quite understanding your composite policy point. It's not insured for operating the vessel in relation to Delos's activities of owning and running a ship as a profit-earning chattel. Is it?
Well, it's insured for its interest. Its activities include taking decisions about what happens to the deployment of the vessel. That's what commercial managers do.
Yes, but that aspect of its activity has nothing to do with its insurable interest, does it? Or the interest which is in fact insured.
That may be so, my lord. That may be so. But nonetheless, the focus is on, in section 4.8c, the focus is on the insured's activities.
The commercial manager may and does take the decisions about which contracts Delos should enter into, but it is still Delos who enters into those contracts, and those are its principal activities as soon as it's acquired the vessel. That's what it's for.
And that falls, my lord, within my financial and legal rubric.
And that's what I was going to ask you, sorry to interrupt. What do you say precisely does fall within your financial and legal rubric, so that we're clear?
So it includes, my lady, and not necessarily comprehensive, but it includes the acquisition of a vessel, the disposal of a vessel. It includes the holding of bank accounts. It includes the signing off of dividends, if there are any. It includes the granting of powers of attorney. And the conclusion of contracts. And those are, in a sense, formalities. But that shouldn't be surprising, because the way in which a group such as NGM sets up its affairs is to ensure that the single-purpose ship-owning company is, as my Lord Justice Males has said, the entity that's a party to the contracts, and quite likely has the money paid to it. And there are formal and no doubt good, or at least understandable, reasons for doing that. But it doesn't mean that its activities constitute operating the vessel for profit, in my submission. So that's what we say about activities. Can I then say something about the managed and organised limb? Because, my lady, my lords, you see from the definition that senior management means those individuals, can be more than one, who play significant roles in the making of decisions about how the insured's activities are to be managed or organised. Now, whether I'm right or wrong about the activities of Delos, whether it's confined as I suggest or whether it's perhaps a little wider, we don't suggest, I said just now, I don't pin my colours to a management mast. It may be, it almost certainly was, that others decided how Delos's activities were to be managed, but we say that Mr. Bayraktaris's role, what he did, and I'll come on to exactly what that was in a moment, it was Mr. Bayraktaris who took decisions as to how those activities were to be organised, or at least some of those activities. We say a substantial part, given the narrow framing which we submit you should give to the term activities. The fact that the statute includes the words managed or organised suggests that those two expressions mean different things, and the judge didn't really grapple with that. She simply said that we were wrong. What does organised mean? My submission is it means something more mundane than managed, and we submit that it means the making of practical arrangements in connection with the assured's activities. I say that because the, or at least a, dictionary definition of to organise is to make arrangements for something to happen. And Mr. Bayraktaris...
So you said, I think you said insurance activities. Did you mean insured's activities?
Insured's activities, I did. I either said it wrongly or...
Well, that's what I had.
Or I said it unclearly, but yes, insurance activities. What did Mr. Bayraktaris do? Well, we can take that from his own evidence. That's his witness statement, which is in the supplementary bundle at tab 15. Page 60. And we see here that he prefaces this paragraph by saying, my role as nominee director is in general, and just pausing there, he says this is what he does for other NGM companies and also for other clients when he's asked to be a nominee director, and was, with regards to Delos, restricted to carrying out the following duties, all of which I do under instruction. And he says here, he completed the paperwork for vessel acquisition, disposals and finance. He dealt with the opening of bank accounts, into which I suspect, my Lord Lord Justice Males, monies were then paid. He signed off on dividends.
Not much point in having the bank accounts otherwise.
Well, wouldn't be doing much, my Lord, no, except that. He granted powers of attorney for the conduct of litigation, and he issued share certificates. And in the light of this evidence, my lady, my lords, we say that although management decisions may have been taken by others, it was Mr. Bayraktaris as director who decided how all of these matters were to be organised. That was his job as a nominee director. The judge said in response to that, oh no, those are not activities, those are an office management function. But, my lady, my lords, with respect, that is not, in my submission, an accurate characterisation of the completion and execution of important documents with legal effect, bills of sale, loan agreements, nor is it an accurate characterisation of the grant of powers of attorney, nor of the signing off of accounts. Those are serious responsibilities, and they are responsibilities that Mr. Bayraktaris not only had the power to execute, but did in fact execute. They are not decisions that could have been taken by a senior secretary or by an office manager, which was how the judge put it, and in any case, Delos had no senior secretary, Delos had no office manager, the only person within it was Mr. Bayraktaris.
But are the decisions made by him, given that he says all of that is something he does under instruction?
The decisions as to organisation in my submission are made by him. Even
Which decisions? We've been looking at A, B, C, D, E.
Yep.
And you're saying that's what he does. And that paragraph is introduced by saying he does all of that under instruction.
He does it under he makes the results happen under instruction, but it is he who completes the acquisition paperwork, ensures that the financing, refinancing are doing what they say they are doing, opens the bank accounts.
Even if one goes as far with your argument as saying those are aspects of the organisation
Yes.
of the insured's activities, the definition says that the person has to be making decisions about how the insured's activities are to be ... organised. In what way does this evidence suggest that he was making decisions about how those organisational activities should be carried out?
In this
decisions about it.
In this respect, my lord, Mr. Mandreas is not, so far as we know, a lawyer. He wouldn't know how to issue a share certificate. He wouldn't know how to draw up a bill of sale. He wouldn't know how to put together a power of attorney. So if those, as I submit, are the relevant activities, it's not Mr. Bayraktaris who says you sell this ship or you buy this ship. But it is Mr. Bayraktaris who makes the decision as to how that is going to be done. Because that's his job as a director. And it's not surprising because he's also a lawyer. As to that, my lady, my lords, the judge appears to have been influenced by a distinction drawn by Mr. Bayraktaris very carefully in his oral evidence, that some or all of what he did for Delos, he did not as a director, but as an external lawyer. And as to that, my lady, my lords, we rely on what is said by Mr. Bayraktaris in his witness statement, where he didn't make his two hats distinction. He said, my role as nominee director was... he sets out here the tasks that he actually performed, and he says that that is the content of his role as a nominee director.
But aren't you allied two things? Here he quite carefully says what he's doing as a nominee director is completing the acquisition paperwork, by which he obviously means signing it, because that's what he also says in relation to financing, refinancing. I'll sign the paperwork as a director. I'll sign the paperwork to open the bank accounts on behalf of the relevant company. The further activity which he may, and no doubt does undertake, to prepare the paperwork in order to be signed will be something he no doubt charges for. And where's the error in the judge saying, well, that he does qua lawyer, not qua nominee director?
Well, my lord, in my submission, one looks here at what he says. He says this was his role as nominee director. Mm-hmm. It was to do the matters set out here. I don't accept that there's a bright line between his legal role and his directorial role.
But we saw earlier in the other papers, I think they were at Divider 3, that actually his fee for being a nominal director was $300 a year.
Yes.
So that fits with carrying out signing duties.
That was his fee, my lady. That's absolutely right. Mm-hmm. That said, in my submission, whether or not he charged extra, and we simply don't know, he is a director because he's an external lawyer. He's not. His selection is not by accident, and he does make clear that he does these various matters in his capacity as director. Nobody else can do those things. It has to be the director, because the director is the only person who can effect these matters on behalf of the company. And that, in my submission, is sufficient to mean that he makes decisions about how these matters are organised. And it is an unreal distinction for these purposes to draw a bright line between his role as lawyer and his role as director. And, my lady, I would add this. We've seen, and your ladyship alluded to it just now, that Mr. Bayraktaris agreed to perform the role of nominee director. He'd agreed to do that for a very small fee, and he'd agreed to act on instructions and thereby fetter his extensive paper powers significantly. And I would submit that that in itself was a significant decision taken by him as director as to how Delos's activities were to be organised. He had taken a decision, no doubt it suited him to do so, he was happy to be a nominee director, that he was going to act on instructions. And that in itself, and in addition, in my submission, brings him within the organised definition under the Act. And finally, and this may come across as a slight cri de coeur submission, but I'm going to make it anyway. In shipping, as indeed in so many other areas, the use of one-ship companies is known, and if it's not accepted, at least it's tolerated. We all know the reasons why groups do it. They do it for tax reasons, they do it to avoid the risk of sister ship arrests, and so on. All reasons very, very well known to this court. I do submit that it's unattractive for a shipping group to say, on the one hand, we set up our operations like this because it suits us to do so, and for all sorts of purposes, you must treat the one-ship company and not us as being the entity that matters. Then to take out insurance on behalf of that one-ship company, and then say, oh, hold on, you must treat our selected sole director, who, on the hypothesis with which we are concerned, knows a matter that is material to the risk to be insured, as being not the company. There is, I accept entirely that is not a submission that derives from the wording of the statute, but there is a having cake and eating element about it. You don't have to reach that finding.
Well, it doesn't necessarily play to your disadvantage as it does in this particular case, because the material circumstance is one which is known only to the nominee director, because it actually relates to him.
Yes.
But he might not know that there's a great big hole in the ship, which needs to be declared to the insurers, because nobody on the commercial or technical side has told him what's been discovered when it goes into dry dock. But if the people who are required to have a duty of disclosure are the people actually managing the business, then you'll be protected.
But that, with respect, my lord, that's an either-or point. That assumes it's one or the other. And I don't accept that. The fact, we say that Mr. Bayraktaris's knowledge should be attributed to the company, but, and your lordship made this point to me before the short adjournment, that doesn't mean that others weren't managing the activities of Delos as opposed to organising them, and therefore would have had the knowledge about, potentially at least, about the hole in the ship and so on. So that I don't, with respect, think that what your lordship has just said to me necessarily follows. That's the first way in which we put our case on knowledge. The second way in which we put it is by reference to section 4(6) of the Act. That is to say, that which the insured ought to know. And it's our additional and our alternative case, if I can put it that way. We could be right on one and not the other, we could be right on the second and not the first, or we could be right on both. Or we could be right on none, in which case the appeal on this ground will fail, but that's, of course, not what I urge on you. So the case is this. It's that Delos and or NGM, I'm going to come presently to the position of FML, ought to have known about the charges brought against Mr. Bayraktaris because they ought to have discovered them on the basis of a reasonable search. This has been given the shorthand constructive or deemed knowledge in the skeletons. I'm not sure that's necessarily a very happy term. It's certainly open to all sorts of interpretation. So I'm going to try to stick to the wording of section 3(4)(a) of the Act. An insured must disclose every material circumstances which it knows or ought to know. What then ought an insured to know? If we could take out, please, the Authorities Bundle Volume 4, which contains the Act and the various materials at which we looked this morning. The starting point is, of course, the Act itself, and that is tab 45. You may be there before me. Section 4.6, whether an individual or not, an insured ought to know what should reasonably have been revealed by a reasonable search of information available to the insured, whether the search is conducted by making inquiries or by any other means. So 2 reasonables there. It's got to be a reasonable search, and you then have to consider what the reasonable search should reasonably have revealed. In other words, both aspects of that are objective. We're also given a little bit more clarification by subsection 7, which says that in subsection 6, information includes information held within the insured's organisation or by any other person. In other words, one can go beyond the confines of the insured itself and the insured's organisation when one is considering the reasonable search requirements. I'll go quickly to the materials. Nothing in the parliamentary debates, you'll be glad to hear. Explanatory notes tells us a little but not a lot. That's tab 46 at page 1404. And we looked earlier at paragraph 55, and I tried to make a point and then drew back from it because I realised I was saying something that wasn't accurate. The second sentence of paragraph 55 makes clear that the actual knowledge and the reasonable search requirements are in a sense complementary, because if there is an individual who is not senior management for the purposes of section 4.3 and 4.4, they may possess relevant information, and that may be captured by the reasonable search requirement. Paragraph 56 deals with what section 4.6 is driving at, and I show it to you for information, but I'm not sure that it actually adds a great deal to the wording of the statute itself, save that it says, it does make clear that the search may extend to other persons. We see something on this also in the Law Commission report, next tab, and the passages that deal with reasonable search are at page 1435 and following. Defining what an insured ought to know. And what I take from this is that the Law Commission was recommending, and this was indeed what was introduced, the introduction of a statutory duty to take positive steps to collate relevant information for the purposes of making a fair presentation. What an insured ought to know is that which should reasonably have been revealed by a reasonable search. And there is a positive duty to seek out information.
Can I just focus on something which will be relevant to a submission you're going to come to? 8.77. We think, next question is what an insured ought to know. We think this should be based on matters which would be revealed by a reasonable search for available information. And that's in contrast to the should in the section which you particularly rely on.
Yes.
When we come to the question of whether Mr. Directaris would have volunteered the information if asked.
Noted, and I will come to that. It is slightly different from the wording of the section to which I did draw your Lordship's attention, which uses reasonably revealed.
In that respect, crucially different.
That may be so, or it may be that the language here is loose, but I do say that, of course, it's the wording of the statute with which you're concerned, and that I'm anticipating what I'm about to say.
Don't worry, we'll come back to that,
exactly.
but I thought I would,
I'm grateful.
Since I'd noticed it, I thought I would just mention it as well.
If it's different, the Act is right, and the report is wrong. Mr. Walsh also points out to me something. Paragraph 886, a couple of pages over. I'm not sure there is a difference if one reads these paragraphs together, because the recommendation is that the insured ought to know what should reasonably have been revealed.
Yes,
by
and that's what finds its way into the statute. Yes.
Exactly. While we are here, could I just pick up one other paragraph, which is over the page at 891. We did look at this earlier, and I was relying earlier on the second sentence and the knowledge of the board of each company. That was obviously in the context of the actual knowledge requirement. But I draw your attention to that first sentence of this paragraph, where a parent or holding company places insurance on behalf of a number of subsidiary or group companies. We expect that the placing company should make reasonable inquiries of those companies. And it won't surprise the court to know that that is something on which I rely in view of what happened or didn't happen here. Now, as I've already said, the person responsible for the placement of the insurance for the win-win on behalf of all the claimants was a gentleman called Mr. Tsouris. And he was the insurance manager for the NGM group, and he gave evidence at trial. And therefore the question rather became at trial, given that he was the only person who was doing the spade work on the placement, was what ought Mr. Tsouris to have done by way of a reasonable search of the information available, and if he failed to carry out a reasonable, if he had done, what would a reasonable search reasonably have been revealed? And the judge found that Mr. Tsouris was justified in not making inquiries of Delos at all. And indeed, he did not make inquiries of Delos at all. The point was dealt with very shortly by the judgment, by the judge in her judgment at paragraphs 215 to 217. And we find that in the core bundle at tab 8. Page 212. And it's paragraphs 215 to 217. The judge makes no reference in these three paragraphs to section 4.6. There's no reference to what would have constituted a reasonable search. There's no reference to any objective standard.
Sorry,
yes.
At 215,
yeah.
has the judge correctly recorded your case as to what should have been asked, namely that Mr. Barracktar should have been asked whether he knew of any circumstances which might affect the risk?
Yes.
That's the inquiry.
That's the inquiry. That is the inquiry. It was also put in a slightly different way at trial, but I don't press the different way in which it was put. So that is what we say the inquiry should have been.
Thank you.
And it was and is our case that as part of the placement process, Mr. Tsouris ought to have asked Mr. Barracktaris, as the sole director of Delos, that question, because he was the sole director of Delos, and indeed he was the sole director of many of the other single-purpose vehicle companies for which insurance was to be obtained. I don't propose to take you to it at this moment, but in our skeleton, paragraphs 19 and following, we've set out what we say the problems are with the judge's conclusions as set out here. First, she suggested that asking Mr. Barracktaris questions would be a somewhat pointless exercise. And she said that that was so because he had no operational role or function regarding the trading of the vessel or her insurance. In my submission, that reasoning is circular. The judge appears to have assumed that material circumstances could only relate to the trading of the vessel or her insurance position. And our submission is that that is not so. In this very case, the judge has found that there were material circumstances. But it is also possible to envisage other matters that Mr. Barracktaris, as the sole director of Delos, might have known, and which would have been material. For example, suppose legal proceedings had been served on Delos in the Marshall Islands in relation to the vessel. For sure, Mr. Bayraktaris might have passed that information on to NGM, but suppose it had happened the day before the placement. Might not have. Suppose Delos was not in good standing at the Marshall Islands Registry. That's something that Mr. Delos would or certainly should know. NGM might not. Suppose Delos had been served with a statutory demand, which might increase the risk of the vessel finding herself detained somewhere. Again, something that Mr. Bayraktaris might know. And of course, and this is our case, suppose there were matters relating to moral hazard, which Mr. Bayraktaris knew and others did not. So we say a reasonable search ought to have encompassed asking that question of Mr. Bayraktaris. I'll come on presently to what it should have produced. Secondly, the judge appears to have thought that the fact that Mr. Tsouris didn't know who the directors of the owning companies were was somehow an answer to this. Well, in my submission, that's not an answer. If anything, it makes it worse, because the question is, what ought he to have known, and of whom ought he to have made inquiries? That's an objective standard. He knew he was placing insurance, or arranging for the placement of insurance, on behalf of individual SPVs. It's not just on behalf of NGM, it's on behalf of the owning companies. They are co-assureds, as we know, and in those circumstances, if one accepts, as I submit you should, that the director of the owning company potentially might have had material information to disclose, then, objectively, he should have been asked. So we say the judge didn't ask the right question. She appears to have looked at this subjectively. She should have looked at it objectively. Ought Mr. Tsouris to have made inquiries of Mr. Bayraktaris as a director of Delos? And she should have given the answer to that, yes. Because, why? Because it was reasonable to suppose, again, objective test, that he might have had material information to disclose. So that's the first part of the test. And then the question is, well, if Mr. Tsouris had made those inquiries, what ought...
Sorry, just before we move on. If the question is, as it's here formulated, or as you think, I think just slightly reformulated it, do you know of anything which it's material to disclose? Is it relevant to take into account whether that's a question that would have meant anything to a person who was not involved in any way in placing of any insurance, let alone the war risk insurance? I mean, it would have been a very odd inquiry to make, to ask someone in Mr. Bayraktaris' position that question alone. One would expect the answer. What do you mean by might affect the risk, and what risk, and what are you asking me?
My lord, I don't accept that asking a director of the ship-owning company, which is a formal position, do you know, and I'm taking this from the judgment rather than I may have elided something on my feet that wasn't my intention, right. Saying to him, you're the director, I'm placing the insurance, do you know of any circumstances which might affect the risk? I don't accept that that is an odd question. If it is an odd question, then no doubt further conversations would have ensued about what was meant. But I don't accept that it is an odd question, particularly of a legal director.
Your examples, other than moral hazard relating to the director himself, relate really to things that have happened in the last day or so, which have not yet been passed on, the legal proceedings which have been served, and he's only just found out about them and hasn't had a chance to tell the managers or principals yet, statutory demand and so on.
The good standing requirement was my other one.
Yes, which again you'd expect, if he knows about them, he'll either take quick steps to put it right, good standing, and in any event will tell his principals about it. And if there's a legal proceedings or a demand, again, you would expect the flow of information from him to be pretty rapid. So your examples only really relate to a very small window of time, don't other than the moral hazard.
2 points in relation to that, my lord. The first is that assumes that he's extremely efficient and acts very quickly and acts entirely appropriately, that there's no delay and so on. One doesn't assume, in the context of insurance placement, that everything is doing exactly what they ought to do at exactly the time they ought to do it. If that were the extent of the duty, then it wouldn't catch an awful lot of information. The second point is that even if that's wrong, and one is only looking at a day or two before, then I say with great respect, so what? That doesn't mean that the point is not a good one, even if it relates to a short time period. To put it another way, is it an answer to say, oh well, if anything happens to one of our companies, then we expect Mr. Bayraktaris to pass on the information in a day or two? It's very difficult in my submission to see how that could be a good answer to a failure to make an inquiry. Again, it comes back to the fact that if you set your group up this way, if you set it up so that you've got a separate company and a director, it's not an answer to say, well, you know, he'd have told us eventually. The question is it reasonable to ask a question about, is there anything that would affect the risk? As to my Lord Justice Popplewell's point that would be an odd question, I said earlier, I don't accept that. It is the sort of question that insurers, brokers ask all the time. Are you aware of circumstances that affect the risk? It's the sort of thing one has to fill in a questionnaire when applying for insurance as an individual. I don't accept it's an unusual question. It would be an unusual question if Mr. Bayraktaris were not a director, if he did not have a formal role within Delos. But he does. He has a formal role, he has extensive powers, and he could be the repository of information. And as soon as you accept that he could be the repository of information, in my submission, that does give rise, objectively, to a need to ensure that he is asked. Then the question is, had he been asked, what would reasonably have been revealed in response to that question? And that is dealt with by the judge in paragraph 217, where she said this: it is true that Mr. Bayraktaris said that if he had been approached out of the blue with a question as to whether there was anything that the insurers ought to be told, he might have deduced that it was a reference to the criminal charges and disclosed them on that basis. Now that, I'm not going to take you to it, but I do ask you to note, that is not an altogether accurate paraphrase, I'm afraid, of what was a long passage in the evidence. It's in the supplementary bundle, tab 30, page 165, and the relevant pages of the transcript, page 44, line 1, through to page 47, line 10. Mr. Walsh was cross-examining Mr. Bayraktaris, who was initially, it is fair to say, a little reluctant to answer the question that was being put to him, but eventually did. He did accept that if he had been asked, he probably would have told them. What the judge goes on to say is, however, on insurer's case, this would not have been an approach out of the blue. That is true. On the contrary, it would have been a question that he would have been asked regularly since his appointment in August 2007. That is true. She then said, it is therefore plausible that he would not.
I don't think it is, actually, because they didn't have a ship until 2017.
That is true, my lord. Perhaps, in that case, delete the second zero and replace with the one. Your lordship is right, because my understanding is that although the intention originally was that Delos would purchase a new building, it never did. So it's 2017, which is perhaps not so long. So it might therefore have been on this hypothesis the second time, because we are talking about placement in 2018. And the acquisition was in 2017. So it would have been the second or possibly the first. But in any event, she then went on to say, it is therefore plausible that he would not have associated this routine question with the charges or mentioned them, given his evidence that he did not think them relevant to the performance of his functions. Now, that, with respect to the learned judge, was not was speculation. It's not based on anything in the evidence. But in any case, it's the wrong question. The question is not, and I take this from the wording of the statute, reasonably revealed. The question is not, what might Mr. Bayraktaris have said if he was asked if he knew of any circumstances that affect the risk. It is, what should reasonably have been revealed? In other words, what, acting reasonably, should he have said if asked? And if our case on materiality is right, and you're going to hear from Mr. Walsh on that in a moment, the answer must, in my submission, be that Mr. Bayraktaris would have revealed the fact of the charges. So on that basis, it is our submission.
Would have or should have?
Would, if acting objectively reasonably.
Yes.
If acting
would have,
should.
because he should have.
Exactly.
Yeah.
Exactly. Can I deal then with one further point before I make way for Mr. Walsh? Yes, my lord.
I understand all you say about
Yes.
the wording of the statute, but it does produce what might be thought to be rather a surprising result. Take a case in which the relevant inquiry falls to be made of someone who's not an employee, and not an agent even, but a third party, and a reasonable inquiry requires a question to be asked, let's say in relation to the state of the vessel of some ship repairers 2 years ago, let's say. And the assured makes those inquiries and is not told that which it ought reasonably to be told. The effect of the interpretation of the statute for which you contend is that failing on the part of an unconnected third party is essentially attributed to the assured. So that the assured loses its insurance despite having done everything which could reasonably be expected of it in order to make a fair presentation of the risk. Now that might be thought to be a slightly surprising result.
Well, as to that, it is a result which the Law Commission certainly did envisage. There was a debate, and I'm going to take your lordship to this in a minute, there was a debate as to whether there ought to be a separate duty on agents or whether the duty should be treated as a duty of the insured. And if the agent, or whoever it is, fails, well, there it is. And that one and where the Law Commission came out is if there is a failure in the search, that is laid at the door of the insured. And that is, it's the Law Commission report, but I'm afraid it's a different chapter. And it is in Authorities Bundle Tab 4, Tab 53. And the reason it's a different chapter is it's gone later, it's out of it. Just so you see from the front page, what we are dealing with here is detailed recommendations, the broker's knowledge. And so this chapter deals principally with what happens if the agent knows something, doesn't pass it on to the assured. And the paragraph on which I rely for these purposes is at page 1544. I can see looking at this wording that it's a slightly different point, and I'm not quite answering your lordship's question. I'm going to try to do that in a moment, though this is related. The obligation to search is not on the agent, it's on the insured. So where a broker or other agent arranges the insurance on behalf of the insured, it may well be the agent who arranges or carries out the search. And a failure by the agent in conducting the reasonable search is counted as a failure by the insured. So I rely on that, but I appreciate, having turned it up, that it's a slightly different
That's
point.
because the duty of inquiry is imposed on the person arranging the insurance as well as senior management.
Yes, it's also because it is the insured which has the duty to disclose. It is not the agent that has a duty to disclose. And there was consideration given to the question of whether separately there should be a duty imposed on the agent And the Law Commission said, and the statute follows this through, no, the duty's on the insured. It's
So
not
the
on
agent is an agent for all purposes.
Exactly. Now, as to the point your Lordship has just been making to me, and it's the danger of going to authorities thinking they say one thing and finding they say something slightly different. It may be that that the result that your Lordship has adverted to is a little tough on the insured because it has asked the right questions. But the wording of section 4.6 is clear, it's objective. An insured ought to know what should reasonably have been revealed.
Well, the Law Commission appear to have thought that it meant would, which is why I drew attention to that paragraph at 8.77.
Yes, my lord, but but I then drew your attention to the later paragraph, which
suggested that the statute be in these terms. And
exactly,
it was.
that's where they were
But
coming
that
out.
rather illustrates that the Law Commission thought that what the statute meant in using that language was would. Now, where that takes one, it perhaps takes one at least as far as saying that in the minds of some who've closely considered the position, the word should does not obviously mean that it's an objective standard divorced from what would in fact have happened.
This far I go, my lord. It's a question of what should reasonably have been revealed, and that must take into account all the circumstances. That must be right. But to take your lordship's example, looking at the person who should tell you about the hole in the vessel and doesn't, you say that's very unfair on the insured if it's asked sensible questions, just doesn't happen to have got sensible answers. But this is not. If that failure, the failure to elucidate and disclose that information, is not laid at the assured's door, then the position is very unfair on the insurer, which is saddled with insuring, on this hypothesis, a vessel with a hole in it, obviously material to, if there's hull insurance and not war risk, obviously material, and yet the insurer saddled with it. And that this is a contract of, it's a two-way contract. It's a contract of utmost good faith. Might be harsh on the insured, but all the material is on the insured side of the line. That's, as one knows, how these things work. The insurer is reliant on searches being done, on the insured asking the right questions, and where the answers are within its purview, getting those answers. And the Law Commission is clear that the questions can be asked and the answers obtained from agents, third parties. In this case, Delos isn't a third party in the sense of some broker or some other agent out there. Mr. Bayraktaris is the director of the insured company. It's the principal assured under this policy. That is who Mr. Tsouris is getting the insurance for, principally. And it's not unfair, in my submission, to say, well, you apply an objective standard to the questions he ought to have asked, and you apply an objective standard to the answers which you expect him to get. Can I say something very brief about FML? In our grounds of appeal, we said that Mr. Tsouris' failure to ask the right questions, as I put it, meant that there was a failure on the part of Delos and NGM to make reasonable inquiries. In this context, I need to address one other point, and it arises out of the case that the claimants make in their respondents' notice that because the policy was composite, FML, the third claimants, their technical managers, not part of the NGM group, can advance the claim independently. Now, we say that there are a number of answers to that point, and you're going to hear shortly from Miss Abawaji on some of them. But because one of the answers is very closely connected with the suspicions I've just been making, I'm going to deal with it. I should say, I understand that my learned friend might object to the argument being run. Oh, he says he doesn't. Good.
It's wrong and irrelevant.
Oh, well, he says it's wrong and irrelevant, but he can address you on that. But at least he doesn't object to me making it. in that case, I can take this very shortly indeed. It's common ground that Mr. Tsuris was the person responsible for placing insurance on behalf of all the claimants. If there was a failure to make reasonable searches, we say that failure is to be treated as a failure of all the claimant assureds, and FML can be in no better position. It's not surprising that Mr. Tsuris was doing the placement of the insurance, because we know from the fleet management agreement, the vessel management agreement between FML and Delos, which is in the supplementary bundle at tab 5, that there was an obligation on Delos to procure insurances covering FML, as you would expect. And we say, in those circumstances, Mr. Tsuris is the man doing all the inquiring on behalf of all the insureds, and so any failure on his part should be treated as applying to all the co-assureds. My lady, my lords, that was all I wanted to say on knowledge. Unless you have any further questions for me at this stage, can I hand over to Mr. Walsh, who is going to deal with inducement and materiality?
Thank you very much, and I don't think we have any further questions for you. But Mr. Walsh, before you get yourself set up, it would help us, I think, if we dealt with the questions on the appeal first. So if you wouldn't mind, Mr. Eggers, we'd be grateful if you addressed us in either order on exclusion and the issue that we've just been dealing with before we come back to the respondents' notice points. I'm sorry, therefore, to stand you down, Mr. Walsh.
The only thing, my lady, the only thing I would add is I think there is an appeal in relation to inducement.
Right.
And there is a respondent's notice in relation to inducement as well.
Right.
So I don't know if that means you wish to hear from Mr. Walsh first on inducement in relation to his appeal, and then I can address you in relation to the respondent's notice.
Thank you so much for pointing that out. I think it would be convenient, therefore, please, if you would reassemble everything, if you would just deal with inducement, and then we can go on. Thank you very much.
Thank you, my lady. I will deal with inducement as succinctly as I can in the time available. The court will be very familiar with the test for inducement under the 2015 Act. Ms Hopkins took you to that this morning. And I'm not going to
Mr. Walsh, I'm sorry to interrupt you again and so quickly, but please would you lift your voice because...
Of course, I do apologise.
Thank you.
Perhaps it might be just quicker if I do take you to tab 45, which is in volume 4. And page 1381, section 8.1. The insurer must show that but for the breach of the duty of fair presentation, it would either not have entered into the terms of the contract of insurance at all, or it would have done so only on different terms. And then, if that's established, we look to the remedies in Schedule 1, which one finds at page 1392. And Schedule 1 then says, well, assuming the breach is neither reckless nor deliberate, if the insured would not have written the risk at all, then it's entitled to avoid the contract of insurance and refusal claims. That's paragraph 4. And if the insured would have written the risk, but on different terms, other than as to premium, the contract of insurance is treated as if it had been entered into on those terms. That's paragraph 5. And if one of those terms relates to premium, paragraph 6, then there's some mechanisms for working out how to reduce the claim proportionately. So that's the statutory scheme. And then
so is the question then what the insurer would in fact have done, as distinct from whether it would have been reasonable for the
it's what they would in fact have done.
So if,
on
you
a fair
had, so if you had an insurer who said, if I'd known that, I would never have done it, even if his reasons for so concluding are a load of hogwash, if he's telling the truth on that, inducement is proved. Is that
That's right. That is right. Obviously, if his reasons are hogwash, it might be a basis for the court to say, well, we don't believe you.
Yes, quite.
But if he's got reasons and the court says, well, we believe that's what you would have done, then that is the outcome, is that those different terms are the terms on which the contract of insurance is treated as being written.
But do the words "but for the breach" require there to be some connection between his reasons and the non-disclosure?
Quite right, Mike. Quite right. So again, if there is none, then on a proper analysis, then it may be a reason for concluding that that's not what would have happened, but for the breach. But if there is a connection, even if the court looks at it and thinks, well, that's not what I would have done in his position, or can't think that reason's particularly
Or a prudent underwriter, let's say.
or a prudent underwriter. He may be an imprudent underwriter, but believable. There are such underwriters, I'm told. So, could I please turn to the judgment, core bundle, tab 8, page 228, and just look at the judge's findings on inducement. So this is paragraph 258 of the judgment. So obviously this is all over because of the fact that we've lost on knowledge. But the judge says, had it been necessary for her to decide the issue, I would have concluded that if all the information referred to in paragraph 233 had been disclosed, and I'll come back to that in a moment, the underwriters would have been prepared to write the risk on the same terms and for the same premium, but with the imposition of a condition requiring replacement of Mr. Baraktaris as nominee director of those SPVs where he was appointed, and then beyond this, insurers have not satisfied me on the balance of probability that they were actually induced to write the policy by the non-disclosure of the circumstances relied upon, and then she says at the end of that paragraph it's academic anyway, which it was. So it's couched in somewhat begrudging terms, if I can put it that way, but the conclusion is that underwriters were induced because, but for the non-disclosure, they would have written the risk, but on different terms, i.e. with the condition requiring the resignation of Mr. Baraktaris. So perhaps another way of putting the judge's conclusion is that underwriters were not induced in a way that was relevant to the success of the fair presentation defence, if I can put it that way. Now, I will come back in a moment to whether this was a conclusion that was open to the judge at all, but working on the assumption for the moment that it was, the question is why underwriters failed on inducement, given that Mr. Baraktaris did not in fact resign at any material time. Or put differently, why did underwriters fail, given one treats the policy as being written on those different terms with the condition requiring his resignation, and that precondition wasn't complied with? And the answer, as the court will have seen, is found on the previous page of the judgment, paragraph 256. And it's the conclusion in the final sentence. In the present case, the replacement or resignation of Mr. Baraktaris is something which insurers would have required as a precondition, and on the evidence, I am satisfied that it would have been complied with. And we say it's that final step in the analysis that is a serious misstep as a matter of law. And we are not in this argument seeking to unpick any conclusions on the facts. Underwriters are simply saying that under the Act, one never asks, well, if matters have been different and a condition had been imposed, would the issuers have complied with it? It's just not a relevant question. The finding that a condition would have been imposed ought to have been the beginning and the end of the counterfactual inquiry. One then applies the revised policy wording to the actual facts. And we make 5 points in support of this submission. Firstly, there is nothing at all within the 2015 Act which says that once one's established the terms on which the policy is to be treated as being written, one then asks whether the insured would have complied with those terms. Secondly, the only reason given by the judge for going down that road is, with respect, not compelling. And we see the reason in paragraph 257 of the judgment, so just below the passage we have been looking at. And we'll come back to the Law Commission shortly, but it's really over the page, the final 2 sentences. However, if that is right, then in the counterfactual world, I do not see why source for the goose is not equally source for the gander, and it should, in principle, be open to the assured, likewise to prove that it could and would have complied. That said, I consider it a difficult area. And so that's the only perhaps slightly homespun way of explaining why it's relevant to look at what the insured would have done. But source of the goose, source of the gander is not a principle of statutory interpretation or law. And thirdly, when considering what the drafters of the statute had in mind, the answer is clear. The Law Commission absolutely did not intend this sort of analysis to be conducted on the counterfactual. Please turn up the report. You've seen some passages from this already. Tab 47, the authorities bundle in volume 4. It's starting at page 1453, the passage. Could I just invite the court, please, to read from 11.79 to 11.84. So we would particularly underscore paragraphs 11.81 and 11.82, which say 3 times it should not be open to the insured to respond and say it obtained low premium elsewhere. It should not be open to the insured to say it could have obtained other insurance on different terms. It should not be open to the insured to say it would have complied with any term the insured would have imposed. So the position of the Law Commission is not, oh, it's all a matter of evidence and what can be proved by the assured, which was the judge's approach. It's, you don't go there at all. One simply looks to see what the insurer would have done in terms of policy terms, if the risk had been presented fairly, and then, if it involves the inclusion of a new term within the policy, one looks to whether, on the facts, that was complied with. The 4th point is worth just unpacking a little some of the circularity which results from the judge's reasoning. As I've already showed the court in these passages, that's something that was foreseen by the Law Commission, and also to those who responded to their consultation papers. We gave the example in our skeleton of the ship owner suffers a total loss because of an engine breakdown, and that causes the ship to founder on the rocks, and assume that that is the sole cause of the total loss. Claims investigated. The ship owner fails to disclose the poor condition of the vessel's engine. It emerges that the ship owner had failed to disclose the poor condition of the vessel's engine, which had suffered serious problems prior to the placement of the risk. Assume that's a material circumstance the ship owner either knew or ought to have known, and then the hull insurer declines the claim on the basis that the poor condition of the vessel's engine was material, and had it been disclosed, underwriters would have insisted on the repairs being carried out as a precondition to cover. It would be a circular argument if the assured could nevertheless maintain its claim by adducing evidence, well, we would have complied with that condition and we would have repaired the engine, even though in fact it didn't, and that was the cause of the total loss. And it's potentially even more circular, because why couldn't the underwriter turn around and say, well, if you'd have repaired the engine, the casualty wouldn't have happened, so why am I having to pay for this casualty or this total loss at all? Similar arguments one can envisage in a non-marine policy. Assume that the assured inadvertently fails to tell an underwriter that the sprinkler system in its factory had been removed. The factory is destroyed by fire during the currency of the policy, and the underwriters discover that the sprinkler system has been removed. Assume the court accepts the evidence of the underwriters that had they been told about the missing sprinkler system, they would have made it a precondition for cover for loss or damage by fire that the system was replaced. Can the assured turn around and say to the court, well, if I'd been told that that was a condition to cover, I would have installed a sprinkler system? Can the underwriter turn around and say, but if you'd done that, we wouldn't be facing a claim for a loss by fire, for the loss of your factory? It's all circular, and this all results from the judge's reasoning.
In those sorts of examples, it would cost the insured something to put the situation right, whether to carry out the engine repairs or to install a new sprinkler system. And if that were a relevant inquiry, I suppose you would have to think about whether credit needed to be given against the insurance claim for the cost of putting right whatever was wrong.
But also, where, my lord, do you stop on the counterfactual? Do you say, well, could the assured have afforded to have replaced the sprinkler system? He says that he would have done it. How far are we permitted to go in this counterfactual world? It's very difficult to know, once you go down that road, it's very difficult to know where one draws the line. And we say there's nothing unjust about limiting the counterfactual to how the underwriters would have adjusted the policy terms with fair presentation. On the contrary, using the language of the Law Commission that we've just looked at, the parties have been brought together under the influence of the insured's breach of the duty of fair presentation. Now, previously, that would have entitled the underwriter to avoid the policy irrespective of the nature of the breach. It was thought that this was, at least in some context, something of a sledgehammer to crack a nut. So under the 2015 Act, the underwriter can, broadly speaking, only obtain the benefit of what it would have done had the non-disclosure or misrepresentation not occurred. But we're still concerned with the underwriter's remedy for the policyholder's breach. And that's why the regime is about adjusting the policy terms to do justice to the underwriter. It's not about adjusting the facts to do justice to the policyholder. So for all these reasons, we say that if the correct analysis is that underwriters would, with fair presentation, have imposed a precondition requiring Mr. Barrack-Tyrus's resignation, that was never complied with, and so there is no cover for the CTL. So that's the first way we put the point. But we also say, in any case, that it wasn't a conclusion that was actually open to the judge that this precondition would have been imposed, and she should have concluded that the risk was one that wouldn't have been written at all. And that is for two main reasons. The first is that was never a case that was pleaded. And the second is that the conclusion was only reached with the benefit of certain exculpatory material, which it said would have been made available on a counterfactual fair presentation. And we say that that material should have formed no part of the inducement analysis. But the pleading point I can take very quickly, and it may be, given the pressure of time, that I just give the court the references to the pleadings rather than labouring through them. It was no part of either party's pleading case condition requiring Mr. Baraktaris' resignation would have been imposed by the underwriters had there been a fair presentation. Underwriters' case, the court will find that in paragraph 26F of the defence. That's core bundle, tab 13, page 277. And that was, they wouldn't have written the risk at all with fair presentation. And issue was joined with that in paragraph 20I of the reply. That's core bundle, tab 14, page 305. And there was no positive case run there that a condition would have been imposed instead, and therefore no positive case either that it was complied with. So no reference in the pleadings. I don't think my learned friends quibble with that. They say instead that it was raised in one of their witness statements, and they pray and aid the second witness statement of Mr. Maldreas. Again, I can give the court the references rather than reading it out, but the references that my learned friends make are to paragraphs 20 to 23 of that statement, and that is in the supplemental bundle, tab 23, page 114. And what the court will see in there, unsurprisingly, given it's a witness statement from Mr. Maldreas, is that there are references to the fact that he could have got Mr. Baraktaris to resign and could have done it quickly. But given he's giving his own evidence and his own recollections, unsurprisingly, it doesn't go through any case that the claimants were running, that the underwriters would have imposed a condition requiring that, nor would one expect it to. So that's the short first point on whether it was a point that was actually live on the pleadings, and the answer to that is no. The second objection is more substantive, and I've got limited time to deal with it, but it's that the judge reached the conclusion that the condition would have been imposed by relying on the exculpatory material, and we say that should have formed no part of the inquiry. Can I show you the court first the conclusion that the judge reached? It's in the core bundle, tab 8, page 218 first. This is in the section of the judgment dealing with materiality, but as we'll see, the same approach that is taken on materiality feeds through to inducement. And at paragraph 233, the judge says, I'm satisfied on the evidence that if the charges against Mr. Baraktaris have been disclosed, the following matters would also have been presented. And then over the page, we have A to F. Just invite the court to remind itself of that. And then, if one moves on to paragraph 247 of the judgment, page 224, first sentence, the judge agrees with my learned friend that it's appropriate for examining inducement to posit a counterfactual which includes the exculpatory material set out above. That's the material we've just looked at in paragraph 233. And then the final paragraph in this sequence is 258, which is the conclusion on inducement. Had it been necessary to do so, therefore, I would have concluded that if the information referred to in paragraph 233 had been disclosed, the underwriters would have been prepared to write the risk. That's the paragraph that I saw, I referred the court to earlier. So it's if the charges had been disclosed, it would have been with the exculpatory material, and with all of that, they would still have written the risk, but with this condition. That's the basis of the finding. And we say that the exculpatory material should have formed no part of that analysis. There's another procedural fairness point here, which is that even assuming exculpatory material is permissible on the counterfactual, the policyholders had not pleaded any of the 6 matters that are identified in paragraph 233 of the judgment, and had not said that those would have been raised on a hypothetical fair presentation. Nor had they adduced any witness evidence saying that they would have been raised. The policyholders in this regard rely on the 2 witness statements of Mr. Mandreas collectively, but again, they're in tabs 18 and 23 of the supplemental bundle. The court will search in vain for anything in those statements to the effect, well, if we've been asked about the criminal charges against Mr. Barrett-Taras, we would also have mentioned the following 6 points. That's just not in there. Indeed, the claimants do not point to any particular sections or paragraphs of those statements in their written case to that effect. So in short, there was no prior notice in either the pleading or witness statement about the exculpatory material that was going to be relied upon. And this meant that the underwriters' witnesses knew about the basis of the counterfactual presentation was when it was presented to them in cross-examination for the first time. And we do say that's part of the, likely to be part of the explanation as to why some of their answers were at times difficult to follow. Indeed, I think the judge recognised that at paragraph 245 of the judgment, they were not giving evidence in their native tongue, and they were dealing with the hypothetical. Now, Lord Justice Christopher Clark expressly warned in the AXA and ARIC case about the dangers of this sort of approach. If I could just take the court to that, please, briefly. It's the authorities bundle. I think it's your volume 1. It's in tab 9. Obviously, it's a case that's will be very familiar to Justice Mayles, the judge of first instance.
No, you can't see that. A long time ago.
I'm sorry, which tab?
Tab 9.
Thank you.
Now, the case has already been mentioned today, which I have forgotten all about.
I know the feeling. Now, if I could just take the warning is a postscript to the judgment, and it's at page 316. Could I just invite the court, because it will be quicker, to read, please, paragraphs 137 to 139. Obviously, it's for the insurer to prove inducement. We accept that. But if the assured wants to rely on some further material which was never part of the presentation, but which they say would have been introduced with fair presentation, there needs to be some notice. It either needs to be pleaded or in a witness statement. And it was not in either the claimant's witness evidence or their pleading in this case. But the second point is that exculpatory material should not be considered at all, at least under the 2015 Act. Obviously, the AXA and ARIC case predates the 2015 Act. And we accept that there was a debate under the old law about when one considers the fair presentation counterfactual is exculpatory material admissible. And just to show the court two sides of that debate, it can be seen in Drake and Provident, which is in tab 16, volume 2 of the Authorities Bundle. It's a motor insurance case. One insurer seeks to avoid for non-disclosure of speeding conviction. The insurer says, well, we wouldn't have written the policy if we'd known about the speeding conviction, given there was also a disclosed fault accident with the same driver. It was all about the rating that the driver had on the underwriter's system. The wrinkle in the case was the fact that the previous fault conviction had actually been reclassified as a no-fault accident, and if that had also been disclosed, well, then the rating would have been different and the underwriter would have written the risk. Now, the Court of Appeal was split on whether exculpatory material formed part of the fair presentation counterfactual. So, Lord Justice Riggs of the majority, you can see what he thought if one goes to page 476 of this tab. And if I could just invite the court just to look at paragraph 74 and just through to paragraph 78. I could ask you just to read that briefly. Lord Justice Clark agreed with that. I don't need to show you that, but that was the majority view that exculpatory material could be included. The countervailing view was expressed by Lord Justice Pill, paragraphs 162 to 164 on page 497. Again, if I could just ask you to read that. Now, it's fair to say that the preponderance of the decisions under the old law favoured the majority approach in Drake and Provident, i.e. that you could introduce exculpatory material. We saw the example of that, AXA and ARIG, where it's allowed, but subject to it being pleaded or flagged in a witness statement beforehand. But now we are under the 2015 Act, and the court must consider whether that position prevails. There are no cases dealing with this issue under the 2015 Act, so we have to do the best that we can with the wording of the Act and what we have from the Law Commission report. The wording of the Act is of limited assistance in that Section 3.5 says that there is no obligation to disclose matters that diminish the risk. But that's in the same terms as Section 18 of the Marine Insurance Act, and we're not dealing here with something that's obligatory to disclose. We're dealing with something that would, as a matter of evidence, be disclosed on a fair presentation counterfactual. But we do say that the Law Commission report strongly suggests that the intention was not to omit such material when considering the fair presentation counterfactual. And it's really the same passages that I took the court to to earlier, in tab 47, the authorities, page 1453, and the passage in 11.80, i.e. the passage, parties have already been brought together under the influence of the insured's breach of the fair presentation duty and are subject to avoidance stuck with each other. We do not think that it is right or realistic to encourage speculations about what would have happened had the parties negotiated on a different basis. Make 2 points in respect of that. Firstly, the reference to the parties being brought together under the influence of the insured's breach, but otherwise being stuck with each other, is, we would suggest, redolent of Lord Justice Pill's observation in Drake and Provident. The terms of the insurance contract are agreed on the basis of what is actually disclosed. And secondly, we say that that paragraph strongly suggests that the Law Commission did not intend fair presentation cases under the new law to involve endless speculation about what other material, beyond the non-disclosed facts, might be put before underwriters on the counterfactual. That involves speculation about what would have happened if the parties had negotiated on a different basis. Now, the judge considered our case on these points, and one can see that from the judgment, Core Bundle, tab 8, page 224. Already briefly looked at this passage, just to remind the court of that. And the answer given by the judge is found in the final 2 sentences of paragraph 247. Just invite the court to remind itself of those sentences. And we say that that distinction is not a distinction that is actually drawn by the Law Commission. As we've already submitted, the Law Commission was discouraging speculation about what would have happened had the parties negotiated on a different basis. And we say that that most obviously includes a counterfactual, where fair presentation is made, and the underwriter responds by saying, well, I won't write the risk then. But the insured then wants to be able to say, well, hold hard, what about X, Y, Z, A, B, C? Does that make a difference to your decision? And we say that that's not what the Law Commission had in mind. And we say that there are very good reasons for that, and limiting the counterfactual inquiry in the manner that we suggest. 4 points. Firstly, one has to consider the circumstances in which this issue arises, namely a breach of the duty of fair presentation. And when we talk about the breach of the duty of fair presentation, the unfairness that we're talking about is to the underwriter because of the failure to disclose material circumstances. It's not about fairness to the assured, who already has the freedom to tell the underwriter whatever he likes when he presents the risk. And the unfairness the court is looking to correct when considering the counterfactual is, in the context of a non-disclosure, the addition of the missing material information. That's what's missing to make the presentation fair. Other information in the insured's favour is not required to make the presentation fair within the meaning of the Act. Secondly, the reforms to this area of the law were principally introduced to mitigate, as I've already alluded to, what was seen, at least in some cases, as the unduly harsh remedy of avoidance for breaches of the duty of fair presentation. It's in the Law Commission report in paragraph 11.1. I don't need to take you to that, but for your note, tab 47, page 1440. And of course, in the context of the old law, the harsher law, one can see why courts may be tempted to entertain, or may have been tempted to entertain something of an escape route for an insured in the form of exculpatory material, one way of mitigating the harshness of the remedy. But under the 2015 Act, we're in the world of proportional remedies, and no automatic avoidance of the policy. That's a pro-policy holder innovation, and so the need for escape routes for the assured is far less obvious. Put another way, just because certain rules, practices developed under the old law, there can be no assumption they must still apply when the playing field has changed in a rather fundamental way. Third, if one goes down the rabbit hole of exculpatory material, where does one stop? The counterfactual inquiry can become incredibly complicated and speculative. Round one, you introduce the non-disclosed material circumstances, and the underwriter says, well, I won't write the risk. Round two, the broker comes back with some material. Round three, the underwriter asks some more questions. Round four, and so on and so on. Where does one stop? Now, I appreciate the court sometimes is tasked with, or is given difficult tasks to undertake in terms of counterfactual analyses. I accept that. But one has to be realistic about whether this is the sort of exercise that can ever be done fairly or with confidence about getting to the right answer. And of course, that's not the case with the bright line we have suggested, i.e. only admitting the non-disclosed fact into the counterfactual. And fourth, and relatedly, it's not always easy to know how to approach this supposed exculpatory material. Objective facts, like in Drake and Provident, where you have a fault accident being recategorised as a no-fault accident, that's one thing. But it's worth considering some of the exculpatory material that the judge relied upon in this case that we looked at paragraph 233 of the judgment. The first of the 6 matters was Mr. Baraktaris's, quote, firm belief that the charges were without foundation. Is the court supposed to be assessing inducement on the basis that that was in fact Mr. Baraktaris's belief? Or is it on the basis that underwriters would have been told it, but there's no assumption one way or the other about whether it's true? The same is true of another of the 6 matters, that NGM, quote, had no cause to doubt Mr. Baraktaris's probity. Is the court proceeding on the assumption that's true, or merely that it would have been said if a fair presentation had actually been made? Now the judge, in paragraph 237E of the judgment, perhaps I can just show you that briefly, page 221 of tab 8. The judge appears to have approached the material on the basis, the exculpatory material, on the basis it was true. So we see that at the end of that subparagraph. Furthermore, the charges had only been brought a few months previously, and there had been no grounds for suspicion in any of Mr. Baraktaris's conduct over the years since his appointment. So there would have been no basis for suggesting the claim to Mr. Baraktaris were all in some dark conspiracy. Now, the judge may have been able to form a view on those matters after the hearing the evidence, but that's obviously not the position of the underwriter in the fair presentation counterfactual. He's not in a position to investigate whether there had in fact been grounds for suspicion of any of Mr. Baraktaris's conduct over the years since the appointment. So for all of these reasons, we say that the position under the 2015 Act is intended to be different to the position that was reflected by the majority in Lord Rix's judgment, and that the exculpatory material should not form part of the counterfactual inquiry, and it shouldn't have formed part of the judge's analysis on inducement. I can deal very briefly with the additional grounds that are relied upon on the inducement analysis, because whilst the policyholders...
Sorry, before you move on to this, how do you meet the point that if you ignore exculpatory circumstances, you're enabling the underwriters essentially to dictate the result by picking on what they choose to plead as the non-disclosure? So, for example, the assured has been convicted of fraud, and it is also the case, that conviction was overturned on appeal. All of this before inception. The underwriters, there's a debate about whether it would be material to disclose it, even with knowing all those circumstances. But suppose the court says, well, it wouldn't be material if you know that they've been acquitted on appeal. If the underwriter simply pleads the non-disclosure as being the fact of the conviction, then on materiality and on inducement, if those are the only matters taken into account, material induced. Do you say in those circumstances that the assured is not entitled to say, well, my conviction was overturned on appeal?
Absolutely, my lord. We do say that. And the reason we say that is that the assured has failed to disclose something that they ought to have disclosed.
No, on the totality of the material, they did not have to disclose the original conviction because the fact that it was overturned on appeal did not make it material. That's my hypothesis in my question to you. But if all the underwriters choose to identify in their pleading as that which ought to have been disclosed is the mere fact of the original conviction itself, then they would get home on materiality. And if the assured is not entitled to say, I'm not allowed to put forward other matters which mean that it was not material, that strikes me as a somewhat unfair result.
Well, it may be that the way in which a plea of non-disclosure, say, is advanced is so vague and so broad that it's then found not to be material and inducing, and I accept that that's possible. But if one has a specific plea and that alone, without having to ask further questions, without anything else, is found to be material and inducing, and the assured has not disclosed that, they have done something which under the statute they ought not to have done, which is failed to disclose it.
No, they haven't. They've made an entirely fair presentation of the risk, because the true facts, when one knows both sides, both conviction and acquittal on appeal, mean there was nothing material in relation to those events which needed to be disclosed. So the assured hasn't, in fact, done anything wrong. On my hypothesis, on the example I'm giving.
I see that. I'm not sure that's actually about exculpatory material. It's not a situation where the assured comes along and says, look, I've got this conviction and I'm disclosing it, and then the underwriter asks some further questions and says.
So has you answered my question now that wouldn't the assured would be entitled to put forward the acquittal on appeal?
No, because perhaps I'm struggling with the hypothesis, I think, my lord, with it being something which ought to have been disclosed but also not ought to have been disclosed if something else had been said. If in and of itself it is a material fact that ought to have been disclosed and it wasn't, well then the underwriter has a remedy.
No, but what I'm putting to you is that the underwriter can frame part of the circumstances in terms which, if they are taken alone, everyone would agree, a prudent underwriter would say that ought to be disclosed. However, when the totality of the relevant circumstances are known, the prudent underwriter would say, no, that wasn't material. And if the effect of this argument, whether you call it exculpatory circumstances or at least other circumstances which the assured wishes to rely on, if they cannot be relied on, then the upshot is that the assured is prevented from explaining that actually there was no material non-disclosure.
The assured
that's in my example, that's as it seems to me the result of your argument.
Well, obviously the assured is never prevented from saying anything to the underwriter when he presents the risk. So it's open to the assured to come along and say, look, there was this, but it's actually been quashed on appeal. So that's never a problem. The arguments that we're addressing here are in relation to inducement. I think what my lord is saying is, well, what it relates to materiality, actually.
Well, I did, but you've lumped them together, and
I haven't.
all right, it's all right.
The judge certainly says, well, if it's good for materiality, it's good for inducement. And it may be...
Forgive me, I thought you were dealing with inducement.
I am dealing with inducement. I thought my Lord's premise was about materiality, though. Yeah. And it may be there's a slightly different approach when one is dealing with materiality, because the question is slightly different. Is would the underwriter of the hypothetical prudent underwriter have wished even to have it in mind, whereas the inducement question is rather more focused. But as I say, there's never an impediment on the assured being able to put a full picture in front of the underwriter. If what you get is an incomplete picture, well then that may not be inducing, because it's just what is presented as an incomplete picture, and if the underwriter pleads what is an incomplete picture, well then maybe that won't be inducing. But if one has sufficient there to say, well actually, this underwriter would have looked at that and said, well, I'm not going to write the risk. The fact that the assured didn't say it, and then didn't provide any further material to contextualise it either, means that the assured shouldn't then be allowed to come along later and say, well, I know I didn't say it, and I should have said it, because it was material and inducing on this hypothesis. But had I done so, I'd have also told him all these other things about what a good chap I am, and it was overturned on appeal, and no need to worry. The assured gets to choose what it presents when the risk is underwritten, and that informs the terms of the policy. And if it chooses to omit certain information, it does so at its own risk. And the question for the court is, well, given the way that the Law Commission have framed the counterfactual inquiry, where is one supposed to stop? And the clear message
I understand.
You has the rest.
Thank you.
Very briefly, there are two on the additional grounds relied upon by the policyholders on inducement. The policyholders seek to uphold the judge's overall conclusion on inducement, i.e. they say that we can't rely on a fair presentation defence, but they also say that the judge applied the correct legal test or assessed the evidence differently, she could have reached the same result, i.e. underwriters cannot avoid by a different route. And I can deal with those arguments very briefly and pick up any points in reply. The argument that this court should assess the factual evidence on inducement differently to the judge and include that underwriters failed to discharge the burden of proof is not an attractive one. The judge rejected underwriters' factual witnesses' evidence that with fair presentation they would not have written the risk at all. She found instead that they would have written the risk, but only with the precondition. We've explained today the legal problems with the judge's approach which led to this conclusion, but if the court is unpersuaded that that approach was wrong as a matter of law, it cannot sensibly re-evaluate the factual evidence. The policyholder's other complaint is that the judge applied the incorrect legal test, and we say that is that criticism, which is specifically about whether the judge applied a real and substantial causation test as set out in Zurich Insurance and Niramax, is not well founded either. As we've said in our skeleton argument, we directed the judge to the very passages from that case which the claimants now rely upon, and it's perhaps striking that the policyholders do not apply do not identify any passage of the judgment in which it said that the judge applied the wrong inducement test when it came to causation. So we say that that point goes nowhere either. One moment, I just want to... It's a point, I'm just being asked to revisit one point, which I shall do very briefly. The point I think I've made already, which was about the difficulty with the exculpatory material and whether one takes that at face value.
Yes.
And we would obviously underscore that point. It's the underwriter themselves cannot form a view on the truth or falsity of some of the points that are relied upon, at least in this case, as matters of exculpatory material. The firm belief of Mr. Barataris, etc., that the charges were without foundation, is a point
I think you made
We'd
those
have-
points.
We'd have to score that. I think I'm now handing over to Miss. Apologies. No, I'm not.
It's our fault.
My lady, I think the position is that that concludes all we wanted to say on the appeal.
Yes.
We have points on composite policy, we have points on affirmation, but those are respondents' notice points.
Yes.
And I had
And material.
And material.
and materiality, also a respondent's notice
Yes,
point.
exactly.
But I had understood your ladyship to
I
be
was
inviting.
asking exactly if that if that's convenient for you, perhaps you would continue, Mr. McDonald-Burgess. Thank you.
My lady, my lords, I'm going to follow my learned friend, Ms. Hopkins' approach, which is to deal with exclusion E first and then their presentation. Unless, of course, you would prefer me to take a different course.
No, that's fine.
Very good. If we can have a look, I'm going to ask you to look at the judgment of Ms. Just Dias at paragraph 104, and it's at page 172 of the bundle. That's tab 8 of the full bundle. And what the learned judge begins with is identifying the provisions of the relevant shipping law in Indonesia, under which the master was prosecuted and so happens that the vessel was detained. And of course, this is the different translation to that relied upon by my learned friend, but I don't think there's any material difference. The language may be not ideal, but it's in substance the same. And then, if one looks at paragraph 105, it will be recalled that the policy excludes, and then the judge quotes from the exclusion. And on the next page, the very first sentence which follows the exclusion, the judge says, the experts on Indonesian law agreed that the vessel had not been detained under any customs or quarantine regulation. Insurers nonetheless asserted that the exclusion applied on the basis that there had been a similar arrest, etc. So the insurer's appeal takes issue with the judge's assessment as to the application and construction of the clause, bearing in mind that it was common ground between the parties' experts, that the relevant detention was not under a customs regulation or a quarantine regulation. So it has to be a similar arrest. And therefore, that is those three words, customs, well, four words, customs, quarantine regulation, and similar, are all key to understanding how this provision should be interpreted and applied. The judge...
If you're relying on what the expert says, doesn't that beg the question of what they understood the meaning of customs or quarantine regulations to be in this clause?
The judge relies on it. The relevant laws in question are the three laws which are identified for the purposes of the analysis by the judge are the shipping law under which the vessel was detained, customs law, and quarantine law. And what is clear is that the vessel was not detained under any laws which were labelled as customs or quarantine. Now, of course, it may well be that there is a differentiation between how Indonesian lawyers or governmental officials will have perceived the words customs and quarantine to other countries in the world. But the chances are there's going to be very substantial overlap between those words because they are words of international scope. They're dealing with the importation and exportation of goods from other countries into this country, and they're dealing with the passage of disease from one place to another. Now, in this particular case, the judge in paragraph 108 on the same page at the bottom identified relevant background, which the judge said was not in dispute. And there are a number of factors which are A to E, which I don't need to set out. The one point I will draw the court's attention to is paragraph D, where the judge says the phrase customs regulations in clause 4.1.5. Now that's referring to the English Institute clauses, not the clauses which we're considering in this particular case, are to be construed broadly. Now, what the judge has done in this particular case is basically say, when the exclusion refers to under customs or quarantine regulations, that essentially means there is a detention pursuant to a law which is labelled as such. And the extension granted by the words or similar arrest ... means where the detention is under another law, but which has the materially the same objective and purpose as customs or quarantine law. Now, that's a perfectly sensible construction. It makes perfect sense and gives full effect to the words customs and quarantine regulation, and also to the word similar. Similar doesn't mean and any other. It means has to relate back to what has been said before, which is customs and quarantine regulations. Now, in this particular case, the insurers, the appellants, put forward 3 constructions before the judge, and only 2 of those are now pursued on appeal. Now, it's just worth bearing in mind what those constructions were, and you can see those summarized at paragraph 112 of the judgment, page 175. Where the judge introduces Ms. Hopkins' constructions, 3 possible constructions. In paragraph 113, the first was that the wording covered any detainment not arising from or actual or impending hostilities. Now, that first construction is not pursued on appeal. The second construction, which is at page 176 of the bundle, paragraph 115 of the judgment, is the insurer's second suggested construction was that in addition to arrests under customs and quarantine regulations, the exclusion covered detainments which are under regulations but not arising from actual or impending hostilities. And then the judge identifies how this differed from, how it was put to her as differing from the first construction. And then, having rejected it, the learned judge identifies the third construction at paragraph 118 on page 177, which is the third suggested construction was not very different from my client's construction, which is the detainment must be similar in nature to a detainment under customs or quarantine regulations. The question is, what does similar mean in those circumstances? Now, as a general point, and then I'll identify how I'm going to structure my submissions on the interpretation and the application of the exclusion. The 2 constructions which are now advanced, the second and third advanced at trial by the insurers, I would submit them with respect to my learned friends, are overly engineered and do not give adequate meaning or attention to the words in the exclusion itself, particularly the words similar arrests and also the reference to customs and quarantine regulations. And moreover, if it were allowed, this would substantially undercut and reduce the scope of cover in relation to non-war political detentions. Now, I'll come back to this. A key aspect of war risk insurance is always been twofold. There's cover for armed conflicts, where it's war, civil war, rebellion, insurrection, etc. Or there's cover for capture, seizure, arrest, detainment, or restraint, which are political acts by the executive of any particular country. They don't have to take place in wartime. They can take place outside of wartime. If, however, my learned friend's construction is correct, that would considerably undermine the scope of cover, particularly the wider construction. And in those circumstances, the court would be justified in adopting my construction insofar as it's ambiguous. I don't say submit it is, but if there was any ambiguity superficially in terms of the application and the meaning of the provision, then the court would be justified in adopting the construction which I put forward. On the basis of the 2 constructions, this makes better business sense. Now, what I propose to do, and I'm going to stop at 4:15 unless you tell me otherwise. I'm going to structure these submissions in 5 parts. And even though I identify 5 distinct parts, they do bleed into each other, and they may not be perfectly contained and isolated from each other, but I'm still trying to give some structure to the submission. So hopefully it will help the court. I know it will help me anyway. And if nothing else, that's a reason why I proceed on this basis. The 5 parts are, firstly, the principles of interpretation, which shouldn't detain us too long. The second part are general observations about the provision itself, which also includes a response to my learned friend's submissions about the history of the clause, which I won't take too long, but I just want to make some points about it. The third is what our case on construction is, and you'll discover, just as a spoiler alert, it's not that different from the judges. In fact, I would say it's precisely the same as the judges. Bearing in mind, I think the judge more or less accepted my submissions, and, well, we'll come back to that anyway. And the fourth is dealing with the criticisms made by the appellants of the judge's decision and why they're not justified. And then finally, I'll address my learned friend's 2 constructions, why they're wrong. Now, I have a couple of minutes, so unless you wish me to stop now, I was going to continue.
You're going to do principles of interpretation?
I think it won't take long.
No.
So the principles, you don't need to refer to it now, but paragraph 61 to 63 of my client's skeleton argument, there is a statement of the various contractual principles of interpretation, which I understand my learned friends accept. I would point out paragraph 107 of the judge's judgment, page 173. In the last 2 sentences, this is going back to a point I made earlier, that in the specific context of an insurance policy, about 6 lines from the bottom, as I have noted above, it is necessary to construe any exclusions together with the insured peril so as to arrive at a coherent construction of the policy as a whole. One of the points Ms. Hopkins made earlier. I also accept that where there are alternative constructions, the fact that one of them deprives a policy of most of the cover which would otherwise provide is a relevant factor in determining which of them is correct. Now, I say that's true, not only in relation to the cover overall under the policy, but a substantial element of the cover, which in this case is dealing with political risks tension. Then an additional point made by my learned friends in their skeleton is at paragraph 55 of their skeleton, which you don't need to look up because we agree with it, which is a point which my learned, the judge just made in paragraph 107 of her judgment. And then we get to paragraph 56 of the appellant skeleton, which is page 79, tab 4 of the bundle. And this is the notion that the regulations exclusion in a marine war risk policy to be given a broad and business-like construction. And this is then referring to Mr. Justice Hamlin's decision, as he then was, of course, in the Atlantic. Now, and a judge, just bear in mind, I referred you to the fact that the judge also had in mind that the English clause should be given the words customs regulation should be given a broad construction in that case. And one has to be very careful about what one means about broad construction. Broad construction does not give a license to the court to construe the provisions so widely as to have no effect, give no effect to the wording actually used in the clause. The fact, and I'll come back to this, the fact that the English Court of Appeal has construed the provision in the English Institute clauses, dealing with the words customs regulations broadly, is because that's all that was said. And the cases before the court dealt with smuggling. And how does smuggling fit in when it's actually not addressed under customs regulations but under another law? And the court came to a solution, which we agree with, that smuggling does come within the notion of customs regulations. Now, even though there is reference in the commentaries and in the cases dealing with the English Institute clauses as to the meaning of customs regulations, such as the Elysia Glacier, in that case, Lord Justice Clark did make it clear that just that not every detainment under customs law will be treated as coming within the terms of the exclusion. Now, I'll come back to this provision, this paragraph of Lord Justice Clarke's judgment tomorrow, just in terms of time now. But the other point I wanted to make is I certainly accept what Mr. Justice Hamlin said, that you have to allow for exigencies in how different laws around the world might be expressed and how they're dealt with. And then, of course, you have to give a settled meaning to word customs regulation when dealing with it. But what I will say is a lot of emphasis was put by my learned friend on the decision in Blaine Richards, which was a US decision. And one has to be very careful about that. The court there does not use the language broad interpretation. There's a reasonable manner. And of course, in that case, what was being interpreted was customs regulations, which would naturally enough, and as in that case, be applicable to provisions dealing with the importation of food into the relevant country. But there was no similar arrest language in that policy. So in many ways, it was like the English Institute clauses, although it had differences as well. Now, the reason I say one has to be very careful about this notion of broad interpretation is because the editors of Colombo on insurance contract law actually describe these provisions having to be given narrow interpretation. So just saying it's broad or narrow doesn't really take anyone anywhere. What the court must do, and I'll finish with this, is look at the words in the provision, ask how it fits within the scope of cover overall, bearing in mind it's cover for war risk, which includes political risk detention, and how it's said to what it's said to exclude. And then once you consider it in that context, we say the answer becomes clear. Now I'm going to finish on that note, unless there are any questions.
Okay. Thank you very much indeed. Can I have an indication of how we're doing? You
Well,
only just begun, obviously, but how do you think we're doing with the time estimate?
I like to think that we'll have equal time, and I think my learned friend had most of it today, but I will obviously adapt as necessary. But I won't be finished until, I would hope, it would be tomorrow afternoon as opposed to tomorrow morning. Of course, I can, if there's...
I'm just thinking we need to also potentially cover the points which have been parked at the moment. On that basis, I think unless it's inconvenient for anybody, I think we should perhaps start at 10 o'clock tomorrow.
Well, it's not, I'm very happy to do that, just as long as everyone...
As are we, my lady.
Okay, 10 o'clock.
Very good.